Well, good morning to you all, wherever you are, from sunny Adelaide in Australia. My name's Greg Bartlett. I'm a partner at Phillips Ormond. Now we're called principals, I think, in our engineering team. I'm an engineer, a chemical engineer, and I also run the Adelaide office for Phillips Ormond and am heading our International Relations Committee. Of course, some of you will have met me before. My main foreign travelling experiences with the Asian Patent Attorneys Association. So at APAA, looking forward to getting back there again later on this year into South Korea. We might catch up with some of you. These sessions are our a new format that we're using to give people a short and sharp introduction, single message topics to tell you about something that happens here in Australia, so that we don't take up too much of your time. It's easy, I think, for us all to grab 10 or 15 minutes to listen to some of these things. So there'll be no great explanations of things. We'll give you conclusions on stuff. There's not going to be a huge amount of case law that we'll talk to you about, or justification for things. So we'll just give you some take-home points that you can hopefully understand a bit more what we do down here. Firstly, though, how are we doing here? COVID seems to have been knocked off the front page in Australia. With the quite heavy flooding we've had in different parts of the country on the east coast, with the difficulties in Ukraine, of course, also front page news of much interest to Australians, and giving a lot of our support for the people in Ukraine. We're completely opened up now with travel, so if you want to come and visit, you can. Not many restrictions. We are back in the office. I'm back in the office here. You'll see we've got our new normal happening with some days in the office and some days at home. So that's where we're at with what's happening here and who I am and what we're doing now. This topic I wanted to talk to you about. You would have come across the things that we do to your patent specifications, either at filing or during examination, those standard things. There might not be any other objections, but we might say, look, there's a few practice issues that we want to change up. So these are those things that we do. There's some that you'll be familiar with that we've looked at and done for quite a number of years. We are allowed to have multiple claim dependencies, of course, so we will introduce them. If the claims lend themselves to that, you'll see that we do that. There's a mention of omnibus claims there. We used to do those, we don't anymore. They're not permitted anymore. So we won't be adding omnibus claims, those claims at the end of a specification that, or the end of a claim set that relate to the drawings or figures, examples. We do remove reference numerals from claims, which of course come up often in mechanical inventions. The theory with removing those, as you'd probably see in other places, is to avoid the possibility of the reference numerals being limiting. So narrowing some reference in a claim to a specific form or embodiment of something that appears in the drawings. We also remove the characterized in that claim formatting. There's no requirement under our law to identify in a claim that which is new. And in fact, we tend not to like to do any sort of highlighting of that type in claims. So where there is a characterized in that phrase in a claim, we do tend to remove it and replace it with including or wherein or something of that type, so that the claim just reads as a whole without any part of it being specifically identified. There are some technology specific things that might happen that are reasonably standard. That's the method of treatment claims, Swiss style claims. For instance, those are permissible here. And so our biotech people, our chemistry life sciences people, that will be a part also of what they do when they're doing these standard sort of reviews of patent specifications. The stranger ones and the ones that are perhaps a bit more confusing or probably not controversial, but a bit weirder, is where there's prior art referred to in the background of a patent specification. There's this first thing. We make a statement, we introduce a paragraph that makes clear that any description of the prior art is not a concession, that prior art either is publicly known or has been elevated to the higher status of common general knowledge. Under Australian inventive step law, it's actually often quite difficult for someone attacking a patent or a patent application to show that prior art has become elevated to that extent. Some aspect of what's gone before has lifted up to the lofty heights of common general knowledge. But there is some case law where a court looked at what had been said by the patentee in the background and did elevate it and said, well, if you're talking about it here in your patent specification, then it's going to be a step easier for someone to say it's common general knowledge. So we try to nip that in the bud by introducing that paragraph. The facts, evidence will show, of course, whether something is or is not, regardless of what we say, but we put that in there to try and slow that down. We do also remove object statements, often as a whole, but sometimes they are only particularly narrow ones. And this is so that we don't have a utility problem, that the promise of the invention, if there's an object statement that's giving promises of what the invention will achieve, we don't want to introduce a potential problem that the material that's covered by a claim across its full scope, not everything there meets that promise of the invention. So again, we're trying to minimise risk, and there have been cases where that has been a problem, where there's been an unduly narrow object statement. Not every embodiment that a claim covers clearly meets that promise, and so claims have been held to be invalid. So we take those out as well. The third point there, the consistory statements, of course, are a little bit old hat as well. We do make sure that we clearly meet our requirements for internal support. I think we used to call that fair basis, but internal support between claims and description. So we make sure that the exact claim language of an independent claim is identically mirrored in the descriptive part of the specification. It's something that doesn't happen, as you know, in a lot of jurisdictions. There's a lot of flexibility with this. Certainly in the US, it doesn't seem to be an issue. Europe, often the same compliance is attended to make sure they're the same. But here, it can actually be quite a problem with this internal support issue. So it's easy to deal with. Once we know what the claim language is of independent claims, we just go through and make sure that that same claim language is clearly in the description. The last one here is probably the one that attracts the most interest from people. And I know with a lot of my travels around Asia, as I've explained what this word comprising was said to mean by an Australian court, must be now 10 or 15 years ago, where a judge, of course, wasn't particularly interested in patent attorneys saying, oh, but Your Honour, I've always thought the word comprising means X. When a judge said, well, I don't really care what you patent attorneys think, I'm going to look at what the dictionary says and the grammatical texts. And comprising was read narrowly. And there was a situation where infringement was avoided because something had been added to a device, and the word comprising was used in a claim, and it was regarded by the court as not permitting the addition of features. Now, there's been subsequent cases where it's been made clear that what comprising will mean will be dictated by the context in which it's used. So there's a little bit less nervousness about this now, but we do still introduce again, a standard paragraph to try and help with this, where we say that the word comprising is to be used in an open sense. Now, that won't necessarily help if it is clear that from the specification as a whole that that's not the case. But that is something that we do look to introduce. Again, a lot of these are risk minimisation efforts as we go through these sorts of activities. The last slide here then is when might we do these things? They are most often attended to at filing. If we make amendments at filing, say on a national phase entry, that's a separate task that happens alongside the national phase entry. Of course, with a convention case, we're not constrained in that way, and we would make these amendments to the specification that we actually lodge. We can also make them, and this often happens when we are requesting examination, and we submit them with the examination request and ask for these amendments to be considered during examination. So it will be the amended claims that get examined. And of course, once examination is commenced, we can also be doing these sorts of practice amendments then. Reasonably often, if there's no objections raised at all, this will be the only activity that we undertake during prosecution of a patent application. We'll just go through and make these practice amendments. It does tie in with our excess claim numbers, so keep in mind that you are only permitted 20 claims at acceptance before you start paying additional fees, and there's a excess claim fees of $100 Australian dollars per fee in excess of 20 at acceptance. So often what we'll do is, once we know what claims are looking like they're going to be acceptable, at that point, and we've made these sorts of practice amendments, we can then look at whether we can be deleting some claims, some dependent claims perhaps. And being able to add multiple dependencies sometimes permits us to get the claim numbers down anyway, without too much loss of additional features in claims. Just the last point, those amendments though that we make in anticipation of examination or when we request examination, they actually won't be incorporated into the specification until acceptance. So if there's any danger of dates being shifted, so if there's any danger of amendments being introduced that might not be picked up by the office as potentially adding new matter, but ultimately you find that they have added new matter, then the date for the incorporation of those amendments will be acceptance. Sometimes, this doesn't happen very often, but sometimes we have clients that might be a bit nervous about that say, no, I want to grab as early a date as I can for these amendments just in case. We do have a mechanism for that. We have to formally request a voluntary amendment, pay a fee, and that amendment will be considered immediately and allowed and given a date. So you can do that, for instance, just after filing, and you might end up with a date that's a year or two ahead of a date that might otherwise be given to amended claims after examination. So those were the things that I wanted to say. Why do we do these practice amendments? Some of them, of course, might actually be important. Some of them probably won't end up being, but if we have an opportunity to make them, so we make them. And there have been cases where a failure with in some of these areas has resulted in infringement not being found or claims being held to be invalid. So they're real issues, not common, but real. And so we do look to make these amendments at these different stages when we can. So that's all for this short and sharp session. Feel free to send either me or the firm an email if you've got any questions about this. That's my direct number. You can call that as well. We are users of Microsoft Teams. Of course, we can use any of the online platforms to have a chat with you if you like. But feel free to get in touch if there's any of that doesn't make sense, or if you don't want that sort of thing happening to your specification, then that's fine too, of course. But let us know if you want to chat about any of it. For now, I hope the rest of your year goes well. I hope that things resolve themselves in Europe. Quite amazing, of course, all of that, and that our new normal, our new COVID normal, doesn't end up being a some sort of new military normal. Thanks very much for your attention. Bye for now.